Good evening, Ma. Good evening, Ms. Shukurat. Thank you so much for joining in.
Hello, how you doing? Hi, Dennis.
I'm very fine, Ma. How about you, Ma?
I'm very well. Where is everybody?
That's what I'm trying to find out, Ma. I'm trying to message them on their group.
Is that right?
Yes, Ma. So please, Ma, just give me a few minutes. Let me try and see if I can get more people to join in.
No problem. I'll be here.
Yeah, all right. Thank you very much, Ma.
You're welcome.
All right. Good evening, everybody. Thank you so much, Esther, for joining in. Please, Sophie, I can see that you're already on the call. Please, Sophie, can you kindly try to still reach out to more mentees so that to the group so that we can have more mentees joining. We don't want to waste so much time waiting so that we can
Okay,
start the
no
class.
problem.
All right, thank you very much. So thank you to our mentor for joining, and thank you, Esther, also for joining. You're welcome to the third week of our JIIPCC mentorship and internship program for the patent drafting class. And we've gone through week one, we've gone through week two. Now we are officially in the third week. We are fastly moving, we are moving very fast into the program, like in the program. And I'm sure that there's still quite a lot for us to learn. There's still quite a lot for us to gain from our mentors, and I'm sure Ms. Shukurat is here to help us drive home some of the points from from all we've learned so far. So moving forward, we have an announcement, an extra additional announcement. So the GC Academy is offering free legal clinical advice for creatives, entertainers, athletes, innovators, and startups. Right. So we have professionals who we have gathered together to ensure that we can give as part of our contribution to society and to some of what we are doing and we believe in as an organization to give back to society. We are giving the opportunities for people to come and have 20 minutes consultation with our professionals, right? So whatever the case, legal case you may have, or someone who has a legal case, you can kindly refer us to them, right? So that they can come and get 20 minutes, a free 20 minutes legal advice from our professionals. So that is the link to the to gain access to that platform, right? And you can also reach out to me if you want more information. So thank you so much. Moving on. All right, so we have our mentors on the call, like I already said, and we're having Miss Shukurat already. She's already on the call. So thank you so much, Mark, for joining. Miss Shukurat, I don't think I need to read her profile anymore, right? We've done a lot of introduction, and we are happy to have you very in our Miss Ma. Thank you so much for joining. And then second, as usual, also we are expecting Mr. Rakesh Sharma on the call. So Mr. Rakesh is not yet here on the call, but we expect that soon enough he will be joining us for this session. We already have one mentee on call, right? So and since the class is being live streamed, we'll still be posting the video of this session to the group. But I would personally be following up after this class if we don't have more mentees joining in. I'll be following up with the mentees on their group and on their platform to find out the reason for their absence. So not to waste any time, all right. Ms. Shukurat, we apologize for the poor turnout, but we just want to give you the floor to give like an opening remark or an opening statement, or just generally your presentation on today's topic. Our topic for today is application, filing an application, a patent application. Right. So, Ma, the floor is yours. Okay, Ms. Shukurat is no longer here, right? But I'm sure she's going to be joining us shortly. Um, so while we wait, please, Esther, if you are with me, I notice you're on the call. If you're with me, please, I would like to ask about the presentation. Were you able to tie it up, and were you able to tie the presentation up?
Just I will send it in like 3 minutes. Just in like 3 minutes, please.
All right, you don't need to actually even send it, right? If you can make presentation from your end after the class, I will get the presentation from you. Is that fine by you?
Okay. It's all right.
All right. So we'll be waiting for. Okay. I'm saying that Miss Shukurat is not on the call, and we don't want to keep the class dormant. Okay, she's back with us. Thank you so much, Ma, for rejoining. Miss Shukurat, can you hear me?
I lost you at some point.
Oh, okay. So I was trying to introduce you, and I was welcoming you to give us your presentation for today's class while we wait for Mr. Rakesh, and also trying to get more mentees to join in for the session.
Okay, so what's the topic for today's presentation?
It's around filing patents application.
Because it feels like it's interwoven, right? We've been discussing everything right from the start.
Yes, ma'am.
You understand? So probably we can. Did you confirm from Mr. Rakesh if he's going to make it or not?
Sophie, I think Sophie did that, but she has not given me the update on whether if he responded to that.
Okay. I wanted to say that probably we should briefly have maybe a question and answer session from the mentees, pending when Mr. Rakesh is ready.
Please, do you have toothbrush? How much?
Okay, Mr.
Okay,
Bless,
let me have
your
one, please.
Brush.
Oh, all right. Okay, so moving on. All right, so Ma, we kindly apologize.
Or
I can't be on.
let's have should I say like a conversational session. I probably will ask questions and let's get people answer just to see if what we've been saying they understand all this while.
Oh, all right, Ma. That will be fine. But then I also want to say that I was able to discuss with some of the mentees coming up from this week. They had a little issues doing their presentation, but they were able to tie up something for the class. So I don't know if you would still want them to present in the session.
Yes, please, they can go ahead.
All right. So please, Esther, if you can, please, we'd like for you to take the presentation, and then after the presentation from your end, then we'll have an interactive session with Ms. Shukurat where we can ask questions, and then she can provide answers based off of everything we've started or we've learned through from the past 2 weeks, right? So Esther, if that is possible, you can kindly go ahead. Let me stop sharing. Esther, are you with
Okay, I'm trying. Yes, I'm with you. Yes, I'm trying to share my slide.
All right. Okay, Esther, it seems you're still having issues. Please, can you kindly send me the presentation so that, I can help you share screen?
Okay, let me do that.
All right, thank you.
I've sent it.
All right, I can see it. I would be opening it just right about now. So while we're waiting for it to come up, please can you just go ahead and introduce the topic so that we can have the slides up while you are speaking.
Okay. Before I even start, first I want to apologize on behalf of my group for we had some issues with creating the presentation. So just to be able to really come up with something tangible that we could use. Our topic for the presentation is preparing patent application and then parts of patent drafting. Okay, the slide is already up now. Yes. Preparing patent application. Yes. So with the introduction, as we've been learning all the while that patent is the system works with jurisdiction. That is the place where the invention has been made and where it has been filed and approved as and granted rather. After the requirements for an invention has been met, that's the issue of novelty, non-obviousness, inventive activity, and utility have been met. The next step is to do a patent search. Now, what a patent search means from what we have learned last time and also from my own hello, can you hear me?
Yes, we can hear you. We can hear you. Please go on.
And from my own research is that patent search is the process of investigating, like looking at existing inventions that are closely related to the one the inventor is looking at to locate to locate one that is closest to it. So patent search in summary is just looking at other existing inventions that are closest to the one that the inventor is planning to patent, to see areas where the distinctions between the supposed invention and the one that are already existing, to see if they've not been patented already. Next slide, please. So according to WIPO, there are some approaches to patent search. And the first one is document field search. That's the document itself in relation to the particular field. That is a broad kind of search in relation to the field of the patent. Let's say, for example, it's medical field. If the invention is from the medical field, the inventor has to do a broad search in the medical area, in the medical line. So the patent will be streamlined to medical field. The next one is keyword. You use a particular keyword. Now, when he has gotten to that his field of patent, he will now use particular keyword in relation to his invention to bring up existing patents. You can also use date of filing of existing patents. You can also use names of existing patents. You can also use symbols and patent classification symbols. You can also use just normal search query. For example, you can use, okay, I already said that, keywords. Next slide, please. Okay, specification drafting guideline. Now, a patent specification is a document that contains the technical aspects of the patent. We learned that a patent is a protection granted for the details of the invention. So the specification document now is a detailed explanation of the invention itself, from what it's used for, the new thing that has been brought in, the new invention, that's the new era, the inventive activity that has taken place, the abstract, all the documentation that has to do with of how the invention works is this patent specification document. Now, there are two types of specification document. We have the provisional specification and the complete specification. A provisional specification is used to just broadly discuss the invention. It does not go into details, just like an abstract. It doesn't really go into details of what the patent is about. Just give you a broad definition of what a summary of what the patent is about. Then we have a complete specification. This one goes into details. It gives detailed account of the patent, what it is, the background, the art itself, the inventive activity, the technical field, the area of invention, and all those intricacies of a patent. Next slide, please. So according to Patent Corporation, sorry, there's a typo. It's supposed to be cooperation treaty. A typical specification document is guided by some parts. The first one is the technical field. Then we have the background of the art. Then the disclosure of invention, brief description of drawings if there are drawings related. Then we have the best models for carrying out the invention, and then the industrial applicability, and then claims. I'm going to explain them one by one. Just give me 1 minute. Okay, yes, the technical field. Now, the technical field talks about the scope of the invention, the subject matter, and the field to which it relates, whether it relates to the food industry or the medical industry or is the tech. It just summarizes it gives details of the field that the invention is related to. Then we have the background of art. Background of art describes the state of art in the particular technical area which the patent relates. The problem it solves, the disadvantages and advantages of the invention. So it describes what others have done in the field and what problems have not been solved prior to the invention itself. Then we have the disclosure of invention. In this place, it now discloses the invention that the inventor plans to patent. It also now reflects the advantage of because it has discussed the background of the invention, that is the lacuna that has not been filled by other invention. It now discloses the advantage of this new invention. Then we now have the brief description of drawings. So in this place now we now have, if it just the technical aspect of, that's why it is called a I think they call it tech legal document, because in this aspect of in this part of the specification document, there are drawings of the patent, the inventive work, the technical aspects that needs someone from that field, in fact, to actually be able to interpret what the document is about. Then we have the industrial applicability, how the patents can be used in the particular industry it has been invented into. And then we have the claims, that's the patent's claim, the new invention, that's the inventive activity that has been invented by the patent. Next slide, please. Okay, so for our last slide, we have patent prosecution process. Now, the patent prosecution process refers to the entire patent process, from the patent drafting to the patent application to when the patent itself has been granted to the inventor. Thank you.
All right. Thank you very much. Thank you very much, Esther. So Esther puts together that Esther helped largely in the putting together of that presentation. It was very impromptu. I had to. She had a discussion with me and some other members of the group, and we had to just figure out a way to still make sure that, irrespective of the current circumstance that they were having with the presentation, with the preparation of the presentation, rather, sorry about that, that they were still able to make presentation in class. So well done, Esther. Thank you so much for the efforts. And to also the other members that contributed their own small quarter to it. Hopefully come next week, right, we would ensure that irrespective of what happens, we have proper presentation in class. So I'll be having discussions with the group come this week so that we don't have these kinds of issues come up in subsequent sessions. So please, we would now be taking over to, or we'll be moving over to what Ms. Shukurat had earlier said we will be doing, right? We just have two, if I'm not mistaken, we have two mentees on call. Others are other devices I'm connected on, right? So please, Ms. Shukurat, we have two mentees on call. I don't know how you want to help us, ma, but please, we are yours to be helped, ma.
Thank you for the presentation. Though I was on and off, my network wasn't that stable, so I couldn't really get much of a presentation. But basically, let's just talk about patents generally. Like we all know what patent is. Patent is a document that gives you legal rights, that gives legal rights to your invention as far as it is new, it is inventive, and is industrially applicable. And we know that even though your patent might be new, industrial applicable, and inventive, it might not, even if it is new, industrial applicable, and inventive, and doesn't have a patentable subject matter, you might not be able to file a patent application for that invention. So the first thing you want to look at, even before looking at the novelty, the industrial applicability, and the inventiveness, the first thing you want to look at is the patentable subject matter. Like, what is patentable? Now you have to look at it vis-a-vis the law of the country, like the patent law of the country you are in. So we are looking at it with the law of the Nigerian Patent Act. You want to make sure that it's not violating public morality. It's not something that exists in nature. It's not something that's to do with plants. Something that's to do with animal. It's not something that has to do with what's it called now? Taking somebody's life. So if your invention is about products, process, equipment, compositions, and so on and so forth, things like this can be patented. But if you look at it vis-a-vis the, let's say, the US Patent Act, for example, the US Patent Act take into cognizance plant and animal as a patentable subject matter. In fact, there are some patent applications, granted applications, concerning inventions for products for committing suicide. And these patent applications are actually granted in the US. So unlike in Nigeria, I don't think the Nigerian government is going to give somebody that kind of 20 years protection period for such kind of invention. However, even if you have inventions like that, should I say, the commercialization of such inventions might be very dicey, because likewise, the government will not want to give you that access to be able to commercialize an invention that has to do with suicide, right? So it might be for some specific cases. Let's say maybe there's an invention for maybe one AK-47 that when you fire the shots, it can kill thousands of people. Such kind of invention can just be limited to probably maybe during the war or things like that. So there are different types of inventions that, even though they might be new, they might have potential subject matter, but the commercialization can be questioned, actually. So if we look at the potential subject matter and you see that, yes, this invention actually has a presentable subject matter, the next thing you want to check out is the newness and the inventiveness and the industrial applicability. And like I said earlier, most of our patents in Nigeria are new, industrially applicable. However, they lack that inventiveness. They are mostly obvious. Obvious in the sense that a person who is skilled in the act, that's the positor now, a person who is skilled in the art can easily get whatever it is person is doing. Once they put 1 + 1 together, they can easily arrive at 2. Say, for example, there was a particular patent that was rejected, that was invalidated after it has been granted. And in some cases, you see that when if you pick invention A and you pick invention B together. Now, let's talk about this in terms of novelty. If you are looking at a patent novelty from a novelty perspective, you can't add invention prior act A and prior act B together to get novelty of a patent. No, novelty has to come from just one prior act. However, inventiveness can come from 2 or 3 prior acts. That is, if there is a patent on packaging, those of us that eat Oreos or all these biscuits that have this kind of packaging whereby the packaging is transparent, that's not the line on now, the inside. When you open the biscuit, it's always inside a kind of transparent tray. Then there's this divider in the middle. I don't know if we know those biscuits. Now, you see that particular packaging. They used to use it for, is it wipes or something like that before? So that inventor picked that particular packaging from wipes and picked a particular packaging from another industry, now joined it together and used it in the biscuit industry. That kind of invention will be, even though it might be new in the biscuit industry, but it's obvious. Because when you pick a prior act 1 and prior act 2 and you put it together, somebody skilled in the act can arrive at your answer. So when you're looking at novelty is just using one prior act. If one prior act can only invalidate novelty, but if you put 2 or 3 prior acts together, those ones can invalidate the inventiveness. So when you're looking at novelty for prior acts, just know that it's just 1 you can use to look at it, not 2. But when it comes to inventiveness, you can use 2 or 3 prior acts to look at how inventive that invention is, because you see most people will pick they'll pick one inventiveness from application A, pick one from application B, pick one from application C. Then they'll now come put everything together and arrive at their own invention. So when you go back to those granted patents and you read up on how these things are applied, it's something that you know that, oh, as a person skilled in the act, if you put this A plus B plus C plus D, you can easily arrive at invention E. And because of this, most of Nigerian patents lack inventive step. Now, when your patent lacks inventive step, does that mean you have to go back to the drawing board and find something else to do? Does that mean there's no way out for you? You can't file anything at all? No. The Nigerian Patents Act gives you the opportunity to file your patent as a utility model. Now, I want us to take note of difference between utility model and utility patent. Utility patent is the same thing we call patent in Nigeria. So utility patent is what the USPTO call their own patent. They call it patent or utility patent, but we call our own patent, right? So in fact, in the US, they have 3 names. They either call it patent, they call it utility patent, or they call it provisional patent. Is it provisional or non-provisional? I think it's provisional. Non-provisional is the one you file first if you want to claim your priority before you now file your provisional patent. So, but in Nigeria, we really don't have those non-provisional, provisional, and so on and so forth. But what we have is something that we call utility model. Utility model is not provided in all jurisdictions. There are some jurisdictions that provide utility model. In fact, some jurisdictions limit it to a particular industry. So utility model is like a smaller patent. We call it smaller patent because the application criteria is less stringent compared to patent. For utility model, as long as your invention is new and industrially applicable, you can file your utility model patent. So utility model doesn't give or doesn't require that criteria of inventiveness, which is always required in patent. And concerning that, you see that patent has 20 years protection period, but utility model has about 7 to 10 years protection period. So because of they've reduced the criteria, the protection period is also reduced. So all these are the things that you might want to consider. So if you have an application that, yes, truly, you know that this application or this invention doesn't really have inventiveness, you can go ahead to file your utility model first. While your utility model has been filed, while you're still enjoying your protection period and all, then you can still work on that utility model and find a very good inventiveness that cannot be invalidated or that cannot be, what's this English we use? This particular English, that cannot be, I can't remember the term, but something that cannot go against your inventiveness. So once you have that inventiveness, then Amecoin, can you hear me?
Yes, we can hear you.
Okay. So you can now go ahead to file your patent application. So that's what some startups do. They call it like additional patent. So because of you don't want that invention to be filed by somebody else, you file your utility model first. While that is running, you go back to the drawing board, try to see how you can bring in inventiveness in a way such that it's not obvious to a person skilled in the act. And once you are able to do that, then you go ahead to file your patent application. So once your utility model protection period lapses, then your patent starts reading. Then if you have any additional thing to add to it, you continue adding it, you continue filing, then you have your 20 years that way in the industry. So that's one thing about patents. But the aspect you now want to look at is how do you now draft this patent application? When last week when we were talking about the main process, the administrative process, Mr. Rakesh took us through what you need to ask, the why, the what, the how, and so on and so forth. So today we'll be looking at the how. How do you draft? What do you need to look out for? Like we discussed, I think in the first class, we talked about the patent search, how important patent search is to whatever it is you want to do. And I think I saw Esther's presentation where she was talking about something search. I didn't really get that. So what that really means is that before you actually going to do any search, you need to understand whatever it is you are searching. You don't just go and just put a name. Like I said earlier, if you are doing a patent search for, let's say, Nivier, if you put Nivier in the search engine, you are not going to find anything, because at the point why they were submitting that patent application, they've not even given the product name. Maybe it was later after the patent has been granted, then they decided to put out a minimum viable product in the market. That's probably so at that point they gave it the name Nivier. So if you are searching a patent application and you're putting Nivier, or you're putting Big Biro, or you're putting Indomie, you won't find it, right? Because you have to look for things that talks about the invention itself. Maybe a writing material or a cooking material, a cooking process, something like that, and put in the elements, the essential elements comprised in that patent application. So if you are doing that, you want to brainstorm the keywords that you want to use. What keywords? If you're looking for a patent application that has to do with bolt and nut and spring, you want to put in all of that, and also use some Boolean operators to streamline your search. You want to use some classes and subclass. She talked about searching, doing your search in classifications, looking at the technical field. What field are you searching in? Is it the medical field? Is it the chemical field? Is it the engineering field? You want to do streamline your search so that you don't have broad patent search results at the end of the day. Then what patent strategy are you looking at? Are you just filing? Do you want to claim priority? Are you filing under PCT? Are you using the Paris Convention? which route exactly are you taking? So all of these things have to be put into consideration. And I think we already talked about the types of search last week. I know Mr. Rakesh explained more on the validity search. So I don't think we need to talk about that any longer. Then for the per ad search, I told you you can use Google Chrome. When you get to Google Chrome, just search Google Patent. It takes you to the Google Patent database, and you can type in either the patent document number or the publication number or the title of the patent application. Once you do that, it will give you different results. It will even ask you, do you want only patent or do you want publication and journals as well? Because publication and journals also add to disclosure. Once you put out a work and that work has, in fact, even the internet also had to a means of disclosure. So you want to make sure you are doing your search correctly. Then drafting your patent application. And the first thing you want to do, you want to identify the invention. What is this invention about? Is it a method of cooking? Is it a process of doing something? Is it a system? Is it a method by process? Is it that you have a method that is doing it? And once you use that method to do it, at the end of the day, you have a product as well. So you want to identify what process, what identify the invention, because that way it guides you when you are drafting the claim. You know if you are drafting for a process patent or you are drafting for a product patent or a product by process patent or an equipment at the end of the day. So those are the things you want to look out for. With respect to the structure of the patent application, there's something called is it a form? I'll say a form. A form is like something that you fill in your details, because when you see any example of patent application, you always see the inventor's name. If there is a statutory inventor and the true inventor, you see their name, you see their details, their house address, everything, in case somebody wants to license that patent application. Somebody wants to license the invention and you don't know who to reach out to, so you can reach out to those people. So your patent application must contain the title of the invention. The title should not be too long, something relatable. For example, in trademark, we will say that your trademark should not be descriptive. In patent, it has to be descriptive because it should not be abstract. It has to tell us what exactly this is doing. Is it a method of cooking? But don't say that a method of producing red biro. When you say a method of producing red biro, and that same method will work for blue biro, green biro, yellow biro. If you limit your claim to red biro, somebody else can use your same process to produce a green biro and a blue biro and a green biro, and they won't be infringing on your patent. Why? Because you already narrowed your patent claim to red biro. So you want to say maybe a method of making ballpoint pen, or a process of making ballpoint pen, or a writing material. You don't want to say a pen, or you don't want to mention that exact thing, because you want to have a broad independent claim. You want to have an independent claim as broad as possible. You don't want to limit yourself, because your claim, whatever it is you claim, is limiting your invention. So you want to have that title, you want to have the abstract, you want to have your technical field, your background of the invention, the summary, the brief description of the drawings, and so on and so forth. So these are all the things that are contained in your patent application. And whatever it is you claim should whatever it is you claim should be highlighted in your description. So don't claim what is not in the body of the work, because whatever it is you claim will take us back to what is in the body of the work. For example, if you're talking about detailed description of drawing, whenever you do detailed description of drawing, there's always a labeling. Whenever I check my phone, I'm going to send you a sample of a granted patent. I know I have money, but I just need to check it. So you see how they labeled it. So the top, they'll label it maybe 1. The side, they label it 2. 3, 4. So when they are writing the write-up for detailed description of drawing, they might say the pen in 1 that refers to the drawing, wherein 2 is the head. So if you go and open the drawing, you see where they label 2. Wherein 3 is attached to 2, such that it's shaking on to 4. It leads to 5, and 6 can do this and that. So whatever it is you are trying to explain, it goes back to whatever you've captured in the body of the work. So don't capture something in your claim that is not reflecting in the body of your work. So that's just it basically. And in as much as we don't do a substantive examination in Nigeria, it is important, or should I say it is advisable, to always do a good job, such that even if your clients want to get that patent protected in other jurisdiction, it will pass. So don't say because, oh, Nigeria just do formality, let me do jagadaga work, because they're not going to check it. It won't be invalidated. And once I have the abstract and everything written, then it will pass. What if somebody brings a claim for opposition? It means you might probably lose that case at the end of the day. So you want to do a good job, a job as excellent as possible. So I think I'm going to end there. Then probably we can take questions and answer. Thank you. Over to you, Dennis.
Yes, sorry, I had a little issue unmuting myself. So thank you so much, Ms. Shukurat. I really appreciate you taking our time to still further go over some of the basics and just run us through what patent application is all about, and just generally everything from research to strategy and everything that in this little time that we may need to know. So please, we want to have a little interaction with our mentor. Please, you have the opportunity to ask Ms. Shukurat any question you may have as regards the topic for the week, and not just even the topic for the week, generally within the line of patent drafting. So we have 2 mentees basically on this call, right? So Blessed and Esther, if it's possible, we would like to take questions so that we can answer.
Okay.
I'm sorry.
Good evening, ma'am.
All right. Good evening, Esther. Please, you
Hi,
can go ahead with
Esther.
your question.
Thank you very much for the talk, ma'am. Yes, I have one question. When you were speaking, you mentioned something, and you said that if, for example, a particular invention, or you give example of that biscuit, that transparent biscuit that they were making use of that particular thing in, I think, wipes, and then someone now realized you could also use it in biscuits to divide the stuff. So does that mean that if there's an independent, how do I put this? An invention, probably when they did the invention, they didn't know that that particular aspect of the invention could be used in an entirely different field, and then someone now brings that into that field in another invention. They cannot lay claim on that as an inventive step. I don't know if my question is clear.
Not so sure. Are you saying that, is it that even if the fields are not related, it
Yes,
could
exactly.
validate the inventiveness?
Yes.
Yes, some things are kind of basic. Okay, let's say a cup. There are these chairs that have hole that you can just put your cup, right?
Yes.
So let's not assume you're saying that you also have a chair that has hole, but in this hole you want to put bottle instead of cup. Does that look inventive? It doesn't, right?
Not so much, yes.
Exactly. So if these things, if you can put them together and arrive at what that person is trying to do without any technicality or anything, then it's not inventive.
Okay, thank you, ma.
You're welcome.
All right. So please, do we still have more questions?
I think Blessing has a question. Am I right? Or is that Blessed? Is that the question? So with the one for novelty, it's basically when you are looking at novelty, you only look at just one patent prior act. You can't add two prior acts together to invalidate a patent. It's just one. But when it comes to inventiveness, you can look at two or three prior acts together to invalidate inventiveness. That's just the simple explanation.
All right. Sorry, I was muted. I didn't know. I was trying to read out the question. Sorry about that, ma. So do we still have more questions? Omar, do you have particular questions you would like to ask the mentees, just as a way to gauge whether what they've been learning so far?
I don't think I have any particular question.
All right. So it seems we'll be having a very, very short class today. But still yet, thank you so much to our mentor, Miss Shukurat, for this time that she has taken to be here with us. And thank you to the two participants. Like I earlier said, we'll do well to address this in your group chats and also presentations and what you're supposed to do for each week, so that we don't have situations where we are supposed to have presentations but we don't. So moving forward, right, I would just like for us to just take a quick screenshot of today's class, and then I think we can call it a night. So please, if it's possible, can we have our videos turned on so that we can take a quick screenshot? For those who are in, like, at least you have a little lighting in your background. Oh, wow. So please, can we have one or two people with a little lighting in their background so that we can take a quick screenshot? Okay, I want to assume. Okay, thank you, Blessed. I think even in my location, they just took the lights, so I'll be taking a picture irrespective. All right, thank you very much. Thank you very much. So once again, I would like to say thank you to those who were able to make it to class. We look forward to seeing you all in the next class. Please do have a lovely evening, and do not forget, JIIPCC is offering a free pro bono session to those who are in need of specific legal counsel. You have disputes, land issues. Yes, you have friends who have those kinds of problems. Please, you can kindly refer them to us. The pro bono sessions are free. They'll be getting free legal. They are looking for lawyers. We can also recommend. Oh, sorry, I didn't know I was muted. Sorry about that. So I was saying, we still have the option.
I heard you. I don't know about others.
Oh, all right. All right. So good night, everyone. Take care.